Good morning, everyone, and welcome. If everybody could just give me a little wave and just let me know, okay, this is working. We are communicating. Wonderful. My name is Michelle Rahl, and I'm the Vice President of Member Engagement for the Lansing Regional Chamber of Commerce. And I want to welcome and thank you guys for joining us this Monday morning. Week 3, I think, of our quarantine here. We're pleased to partner with Foster Swift to launch this webinar series. We know that this is a crucial time to get information out to the business community, and we appreciate and recognize just the tremendous effort that all of our members, that all of our businesses have done in supporting one another through these trying times. Additional programs we're looking to do with Foster Swift include cybersecurity, contracts, business continuity. So look for more information coming from the Chamber on these webinar series. We're going to continue to build out these digital offerings, these different digital networking and information sessions. We recognize that it's not business as usual, but we want to do business as much as possible. We do have a series of questions to sort of guide this discussion, but we do welcome questions via the chat function on Zoom. I'm sure many of you are well equipped in how to use Zoom by now, but on the button on the bottom, there is an opportunity to submit questions via the chat function. Those will be monitored and fed to the panelists toward the end of the program. As we wrap this program up, we will send out a summary email with a link to this recording, some other links to additional resources, and some further contact information. So we want to continue to build a stream of information and data sharing. And now the role of a good moderator is to get out of the way and let our experts really lead and drive the conversation. So that's exactly what I'm going to do. I want to introduce Cliff Hammond, labor employment attorney with Foster Swift, and Julie Mann, senior director, corporate human resources with Neogen. And let's just kind of start right with a 30,000-foot view. The Families First and CARES Act was passed. Let's try to unpack some of the major pieces out of that legislation. Cliff, if you'd like to kick us off, that'd be great.
Yeah, sure. Thanks a lot. So the one thing that people ask me about is, what are the major components of this law? And I'll tell you what's not there. And a lot of people think it might be there, but it's not. There's no government benefit for large amounts of toilet paper that you may have stocked. So that's not going to be there. So if you're looking for something to maybe get a tax credit, that's not there. So let's move to what it is. Okay. So essentially what it does is it says, look, we understand that because there's a pandemic, there are going to be people out of work. And if we're going to have lots of people out of work, we got to make sure that they're allowed to, so we don't get everybody sick. Obviously, this law was made before we knew that states were going to go ahead and shut down most of the workforce. So it was done in the idea that one of two things was going to happen. Number one, we were going to have people still coming to work, but we didn't want people who were sick or caring for people that were sick to be without the opportunity for leave. So that's what the 30,000-foot view of why they did this. And also they anticipated a lot of people probably would telework. So there's a little bit of understanding what that is too. So understanding what the concept here is, the concept is to give people leave if they need it. You have to fit it into where we live today, which is in Michigan under this, obviously this shelter in place order from the governor. So what it does is it basically has 6 categories of people who are eligible for some sick leave. So there's a sick leave component, emergency sick leave component, and then there's an addition to the Family Medical Leave Act and a redefinement for this very limited purpose of who's covered. And I know there's a lot of misinformation going on out there, and a lot of it has to do with the fact that the way we pass bills, the way we do our laws is usually like this. The people in Congress get together, they yell, they scream, they argue, they put some piece of paper together, they call it a law, and then we figure out later on what it really means because the administrative agencies kind of come out with rules and guidance. And as employers, we usually wait for those guidance to come down, it takes a little bit of time. We don't have time for that now. So what we've done in the last couple of days is we've seen these bills and people are, hey, I heard this bill is going to get passed on Wednesday. What do we have to do? And it's like, okay, well, we know some of it. We have to think about others because most of these bills, they kind of are odd. They're quirky in the way that they don't really fit nicely together and they don't fit with the real world. So we've had to do the best we can in a very short period of time to put them together. And the 30,000-foot view is If you are somebody who is isolated because your healthcare provider, your doctor, whatever, told you you're on quarantine, then obviously you're going to have some time off. That we want you to have that time off. If you're caring for an individual who's been quarantined, we want that. If you're in isolation or quarantine by an order of the state or local government, then we want you to have time off. If your child, your son or daughter, is out of school, or you can't get your kid to daycare and you can't work as a result of that, then obviously you have some time off. If there's some substantially similar issue that the federal government dictates, says, hey, look, this is something we also think should be covered, then you can have some time off too. Those are really the things that we're looking at here. And obviously, if you have symptoms, right? If you have symptoms of COVID-19 and you're seeking a diagnosis from a doctor, you don't know yet, but you're going to go look. Obviously, we don't want to wait until you've got the confirmation with all the testing issues. So we go ahead and give you leave for that. Now, the sick leave allows you to have up to 80 hours for those 6 things. And then if you're part-time, which means you're less than 40 hours, you basically prorate it. And the way they tell you to do this is that you take a look at how you would work in a 2-week schedule. If you would work 30 hours average per week, then you go ahead and you get 60 hours worth of pay. If you worked, maybe some weeks you work 80, some weeks you work 20, it's up and down, you don't know what it is, go back 6 months and do an average of that, and we'll pay you based on that. But it gets a little more complicated because there's a cap. There's 3 of these absences that actually have a full reimbursement at your rate of pay, and there are 3 other ones that only give you 2/3. So if you are under an order from a doctor that you have to stay home, if you are, basically seeking a doctor because you have symptoms, then obviously you'll get 100%. So if it's for something that you actually have, it's an order that tells you to stay out. If you are subject to a state order or a local order from the isolation order or a quarantine, obviously we want you to get your pay for that 80 hours or whatever component you have. If it's for any of the other ones, the ones that you're taking care of, an individual that might have it, your son or daughter's out of school, or there's some substantially similar issue that comes out from the federal government, then you get 2/3 of your pay for that period of time. And people ask, well, who's qualified for that? And it's every employee. And so we'll get into a little bit of more of the details there. But basically what happens is if you have 500 employees or less, you're under this rule. So if you have an employee and at the time that they apply, you have under 500 employees, then you have to pay them. It's not the look back 20 weeks or anything like that. It's just at the time you apply. Same thing for the FMLA extension. The FMLA extension allows you to get 2/3 of your pay for one reason and one reason only. And that is because you can't work or telecommute because you have a child out of school or their regular daycare provider is not available. And people always ask me, well, what if I offer them the opportunity to work from home and I'm flexible with hours? Well, the Department of Labor said you really should try to work out. So they say, look, I don't have school. I've got my 17-year-old senior. I really have to look after them, but I can't work. And you say, well, I'll let you work early in the morning. I'll let you work late at night. You try to work with them. And they say, no, I just can't do it. I can't do the job and I need to leave. Then you have to give them the leave. And the same requirement that we talked about goes into play with them with 500 employees or less, except they have to be employed for 30 days at the time that the leave is requested. So that's a lot to think about for a minute because there's a million variables that you have to ask from those general basic concepts. The question would be, well, what if I can let the person work? Do I still have to can I do it in an intermittent stage? Can I allow somebody to work at home that is sick and has symptoms? There's a million variables that we can go over. The good news is that a week ago, we were really unsure on a lot of these things. And specifically, I'll tell you one that a lot of people came up with is when we had our shelter in place order come down a week ago today at 11 o'clock, a lot of people said, well, wait a minute. The first thing that you get this paid sick leave for is for the purpose of a local quarantine or isolation order. Well, that sounds an awful lot like an isolation order, right? The governor tells you, go isolate yourself in your house. So does that mean that every single employee all of a sudden now gets some pay, at least for 80 hours? And there's a lot of going back and forth about, well, can you furlough people? Can you lay people off? What if I do this? Do you still get it if these things happen? And what's happened essentially is the Department of Labor has done what they were supposed to do, which is put out some responses. And I would urge everybody here to go on to the Department of Labor's website. And I'll give you the website address so you can look this up, because it has 59 different questions, common questions. Not really an FAQ, but it's a question and answer. And I really think that they did a very good job of answering most of the questions that employers are going to have for most situations. And I really think this is probably one of the better ones that I've seen. And I'm going to give you the address now. It's dol.gov/agencies with an S /pandemic/FFRA-questions. Or you just Google up DOL-FFCRA questions. I strongly recommend anybody on this call, when we're done, to go there, because when I have a question, when people ask me, the first thing I do, I pull up, I have on my browser, I have up the actual law, all right, so I can search that. And you can actually get that online too, it's searchable. But you'll see that it's a disaster. The way it's written is kind of a mess. You have to kind of go through and look at the FMLA and insert it and all that. But then you go to this, and I think this is extraordinarily helpful because the way that it lines up, it actually allows you to answer a lot of questions. So for instance, obviously a lot of the employers that are going to be involved now, they're really upset about this, are going to be small employers, right? People who have never had FMLA before. They don't know how the FMLA works. Well, what we have is, because it's everybody under 500 employees, that's the big issue that's going on. The Department of Labor in the law basically said that the Secretary of the Department of Labor could come out with some ways in which certain small employers under 50 employees could be exempted. They might not have to apply the sick leave and the extended FMLA. And if you look at the very end of that FAQ, you will see two specific questions on exactly what are the terms that you can actually be exempted potentially. Essentially, if it's going to cost you more money and you can't be viable, obviously is one of them, or if nobody else can do the job, you may be able to deny the person who asked for a leave under this. And they've got specific, I think, guidance that allows you to understand it. Now, it's not going to be perfect. You may still have to go through it a little bit, but at least it gives you the framework which you didn't have originally. We didn't know what it was that a person could be excused by. So the pieces are falling in place now so that we know. And I think from a 30,000-foot view, if you will, it all comes down to a very simple issue. Number one, do you have 500 or less employees? This FAQ, or this questionnaire from the Department of Labor, really helps us out a lot, because what it does is it does what we thought it would do. Is the Department of Labor wants you to count all your employees. They don't want you playing games. They intend this to be something that you should have applied to people. And you're supposed to have all your full-time employees, all your part-time employees, even your temps that you use. And I can't stress that enough. Please take a look at the FAQ, how you count your employees and what you count as far as the individuals that are going to count for whether you're in. Then the next question that they answer is, how do I have to pay it? And I think they do an excellent job. Imagine you're thinking about shutting the place down. Imagine you're thinking about furloughing people. There's been a big debate. Should I lay people off? Should I furlough people? Should I put them on a leave of absence? Is there a difference? And the answer has been since day one, well, I don't know how it's going to work out, but what we found out now from the Department of Labor is really roughly what we probably should have known in the first place, and what I think I've been advising most people. If you lay everybody off before April 1 and you close your place down, then you don't have to pay them because you're not an employee. They can go file for unemployment. And as you might have heard, there's another act, a big stimulus bill with lots of cash for everybody, that's going to give lots of money potentially to people who file for unemployment on top of their eligibility already. Can I get both the unemployment and this leave? And the answer is no, you cannot. You can't get both. You can't double dip at the same time. So if I am eligible, it's going to be a question of, are you working? If you're furloughed, there's a specific FAQ in here. If you're furloughed, you are not eligible for either the paid sick leave or the paid extension of the FMLA, period. So I think that answers the question. If your place is closed, if you decide you're going to lay everybody off, and let's just say you even have a person who's on sick leave, they're out 3 or 4 days, and you decide, you know what, we're done. We're closing the place down, and nobody's going to be working at all, not at home and not at the office. They're not going to be eligible for it. But if you have everybody working from home, and as a result of a COVID-19 qualified absence for the paid sick leave or the extension, then they would be qualified. So if you can work, then you get it. That's the whole point of the bill, right? So that people who can't work. A lot of people ask me, well, what if somebody's working at home and they say, I need off because of my kids? Well, the answer really comes down to this. If you try to work with them and at the end of the day, they still say they can't work, it's not about whether it's reasonable or not, they're entitled. So if you're telecommuting, teleworking, and you say I can't work because of my kid's school or daycare not being available, the long and the short of it is they're eligible for it. And it could be intermittent. Could be on an intermittent basis. I need a couple days, maybe Monday, Wednesday, Friday, I can work, but I can't work on these 2 days, on Tuesdays and Thursdays. The opposite is true if you are actually requiring individuals to come as critical infrastructure workers to come into work here in Michigan. And let's just say they say, hey, I've been diagnosed and or I think I've got symptoms and I need to go to the doctor. Well, if that's the case, you can't have somebody work on a intermittent basis if they've got that particular qualifying event, if they're actually working in person. So the reason why is you don't want people coming in and out of work, getting everybody sick. So it kind of makes sense, inherently makes sense. And if you look at the FAQs, there is a differentiation between people who are in the office working and the people that are not in the office. And then the next step is, who is a critical infrastructure employee that can come to work and he can work? Now, the bottom line is that the governor's executive order has some interesting, unique twists that just happened on Friday. First of all, I think the order is pretty clear. Stop working. Stop coming in the office unless you fit into very unique and specific guidelines. So don't try to broaden it. Your job is to lessen the number of people that come to work. Even if you're in an industry, it's an infrastructure, a critical infrastructure designated area, you're supposed to find out which of those employees you need to have, which ones are required to be there. And if you can work them remotely, even if you're allowed to have them come in, have them come at work, at home. Send them out. Don't bring them into work. Don't get people sick. That's the whole goal, and that's what it's actually saying here. Our job is to designate those individuals. Now, if you have certain people that work in vital public works that are designated here, if you're in the healthcare sector or you're a volunteer for life and death situations, you don't actually have to designate those individuals. They're allowed to come into work to the extent that you have to, but the governor says you're still supposed to work at home as much as you can. Then you move to the other areas. There are critical infrastructure workers, and the governor basically says in her order, and you can look at it online, and I very, very much encourage you to do so. You'll see there's all kinds of industries that are identified. There's healthcare industries, there's energy industries, there's certain types of water and wastewater industries, and critical areas that we need to have moving in our country, and it lays them all out. What it does is it refers to a March 13th executive order from the Homeland Security on cybersecurity. And I want you, really important that there's a hyperlink within the executive order. You can Google this up and go to the hyperlink and look at that. And the goal is to see, and it's, again, this is just guidance. It's not required, but this is what the governor wants you to do. Look at there and see if you fit into those very tight categories of things that have to be open. And if you need to do that, and you're in those, if your employee provides this, not if you're in the industry, it's if your employee provides those services, then you're a critical infrastructure employee. And that's different than being in the industry, because the whole industry that's covered isn't necessarily exempt. It's just those that you need to do the things that are in this infrastructure program the Department of Homeland Security has identified. So within that, what you have to do is see if you fit. And if you do, then those individuals are exempt and they can come in person to work, all right? And then if you need others to supply you, suppliers who you need to continue those type of services, those can be designated as well. But as an employer, you have to designate your employees. You can do it verbally now through tomorrow, but by tomorrow you have to do something. And even if it's by email, you're going to have to tell them in email you've been designated as a critical infrastructure worker. And there's been some question about whether you need a travel letter. Do you need papers like we're in, maybe in World War II where you're traveling around and you're going to stop? That's not going to happen. The governor has said we're not going to do it, but just in case, you can always give people a travel letter.
And I think this might be a good, opportunity to kind of segue. There's a lot of things I think for the employers to kind of unpack, but how do you communicate this on the other side to all of your employees? And, I know, with Neogen, I think that you guys have some working on site and also some working from home. So, I mean, Julie, you're kind of living both sides of that coin right now.
Absolutely. So a couple of things going back to the 500 and less employers for the Family First Act. So yes, we have FAQs for those employers under 500. The question always is, so how does that relate and what's the responsibility on the employer side from the over 500 employees? And, what I've read says that, that's up to the employer to take, to figure out what that best solution is. And so, for those of you listening, and I looked at the attendee list, I mean, there's many companies that are over that 500 employee mark. And, there's not, and correct me if I'm wrong, Cliff, but there's not the guidance on what do we do when you're over 500. So you kind of start looking at your own practices, your own policies, you figure out where you have gaps from kind of what's out there from a guidance standpoint for the smaller employers, and then figure out how do you kind of navigate that into your workspace. And then, to Michelle's point, and then it's all of the communication that goes behind that to be sure that your employees are aware. At any time, we all know that from a communication standpoint of view, I always say when someone says, well, how much do you communicate? I'm like, you communicate, and then you communicate again. Especially in, these unprecedented times. I can't stress enough to everybody that once you think you're communicating enough, you're not. So to go backwards to that kind of that correlatory for the larger employers, it really is taking that responsibility to figure out what you're going to do at your own work site and doing the best thing possible so that you're still mitigating the things that Cliff talked about relative to why the act was in place, because you still want to protect your workforce, you still want to protect your employees. Those are all the things that are at the top of all of our mind. At Neogen, we are designated as a critical infrastructure employer by the Department of Homeland Security, and we do have essential workers. To Cliff's point, to communicate out on a letter or some type of a guidance to the employee, I did read over the weekend that they were not required to have a letter. That was not clear right in the beginning. So last week, Neogen actually sent a letter to all of our employees so that they could carry that on their person as they went back and forth under the guidance. If they did happen to need that letter, they would have it. I saw over the weekend that that was not going to be a requirement to have a letter, although you do have the responsibility to communicate that out by tomorrow. So those are two different things. But I will tell you, even it was yesterday, we had an employee coming in to Neogen, and they did get pulled over. They were asked, and they did not have a letter. Now, they weren't stopped from coming to work, but again, that's where that communicate can come into place, because you want to be sure that employees know, that they are a critical infrastructure employer, and that they do, they need a letter, they don't need a letter, but again, just to try to help make them feel more comfortable in a time where, everything is changing on a daily basis. So I would encourage, everyone to think about what methods do they have. At Neogen, we've got both manufacturing, and then we've got some office folks. We've put remote as many employees as we can. We've probably got about 50% of our workforce remote right now. But we still have operations that are critical to the food supply. Neogen, I think, is one of those little best kept secrets in Lansing. Not everybody knows what they do. Most people go, I think you do some kind of a science stuff or something like that. But Just for everyone to know, I mean, Neogen is responsible for the quality, the quantity, and the safety of the food supply. So if Neogen was to shut doors, we would not have a food supply. It would distinctly impact our food supply from a quantity, quality, and safety standpoint of view. So we're very critical to be sure that there's food still on the shelves, to be sure that animals are still safe. And so that's kind of how we get that critical infrastructure employer, and therefore those employees. So you do want to, help your employees understand that. With the Ingham County Health Department notification that came down Friday at 4:32 p.m. for all Ingham County businesses to be in compliance by 5 p.m. I'm sure everybody had fun scrabbling with that relative to the health screening. Again, that kind of creates that level of, concern for the employees. So, we, before the day ended on Friday, even put a note out to our employees to let them know that we were aware, we were going to comply. Here's what they could expect. Here would be the changes in process. So you want to think about those things overall with, all of these new pieces of information coming in.
That's a really good point that you made there, but I want to make sure everybody understands the Family First Coronavirus Relief Act talks about 500 employees or less, and it talks about the ability to have paid leave under both the sick leave component and the extended family medical leave. But the executive order is for everybody unless you're exempted. And so that's an important component. I think a lot of times what happens in these things are happening so fast, so furious, so much information, you're trying to keep on top of it. Those apply to different groups for different reasons. They have a lot of intertwined situations, and you may have the company next door might have critical infrastructure workers, so you see the parking lot full. Well, the reason why is because they fit within, like you were saying, some exemptions for those employees. And even though there is now some guidance from the state saying you're not going to need travel papers, again, if a person does get stopped, somebody's trying to do their job, they're a law enforcement official, and they're just trying to make sure everybody's safe, they may actually ask a question for an employee. So communication is critical, and really you've got a lot of different layers because, as you just said, you've got these different counties, Ingham being one of them, who's trying to do their best to say, hey, and by the way, here's something new you got to add on top of everything else you're trying to figure out. And you got to put a policy up, and you got to put a posting up, and it's effective immediately, and you got to take temperatures or at least ask people until you get your thermometers because you can't find them anywhere. What's going to happen. And if people if they've traveled outside the state of Michigan, say you crossed over the state line into Ohio with 1 foot, you technically, according to the Ingham County order that just came down, and I encourage everybody to go take a look if you haven't already, to make sure you have that up. If you've got in-person people coming in, you've got to do some protocols on allowing people to come in, some questions you've got to ask. And then there's some protocols on how long you can keep people out. So those are all things, and every county and every locality, they may be doing their own thing. And you've got to keep on top of this. And it's a nonstop battle because the information keeps changing, and it's okay because that's what we're supposed to do. We're supposed to keep on top of our own industries. And even within, for instance, healthcare, there are different types of healthcare providers. And the state of Michigan obviously originally said the healthcare and public health providers were the type of critical healthcare individuals we wanted to continue to come to work. But they've actually issued some guidance from the state as to, look, let's just say you are a public health or you are a healthcare facility. There are certain types of healthcare providers that we actually don't want you to do non-emergency procedures. I want you to put a procedure in place to postpone those. So it's very important that we're working. If you're over 500 employees, you may not be required to pay people for these leaves, but you still have to be understanding of these different components. And I think that goes to the other issue, which is money. It's a lot of money. If you have to pay people off, and it becomes a decision, right? The decision is, should I lay my people off, put them on furlough, whatever you want to denote this not working situation, or should I continue to pay them? And you may have heard of the CARES Act. The CARES Act was passed late on Thursday, and it does touch on and kind of clarify some of the language, some of the problems with the initial FFCRA. Kind of clears it up, but for the most part, you probably know it has two major big money components that we have to worry about. Number one, you can go out and get a loan, different types of loans, but one you probably heard about to cover some of your payroll expenses if you're going to pay people. And if you keep everybody around and you don't reduce them too much, you can get that completely forgiven potentially at the end of that loan to cover maybe up to 8 weeks of your payroll expenses, which includes not only the money you're giving them, but some of the healthcare expenses you might have, some of the interest on mortgage, your lease, and other types of relevant utilities that you might have so that you can keep the place going. And as in business, you need to make a quick decision. Do I want to do it or not? You may have a question about whether I laid somebody off. Can I bring them back? There is some language actually to bring them on, continue that out. So that's a big deal about whether you're going to telecommute, which means allow your employees to still work and still take money and work from home, or just shut down operations. It also has a second component to the CARES Act, which is a enormous amount of unemployment pay on top of your regular pay. So let's just say you lay somebody off or somebody's off of work. They may qualify for unemployment, say up to $362 here in the state of Michigan. So you get $362. Well, the CARES Act essentially is going to add another $15 an hour on top of that, the equivalent $600 a week. So you could have people who make less than $50,000 a year say, man, I think I'd like to be laid off. All right, that might not be a bad deal. I can sit at home, and as an employer, you might say, hey, it might be in the best interest of my employees. As well, other employees might say, yeah, I'd rather keep working. I make more than that. I'd rather keep my job. Can I telecommute? And as an employer, you've got to do a cost-benefit analysis. Number one, which is in the best interest of your employees. Number two, as an employer, can I really stop operations? Does that make any sense? And if you're looking at the loan component, you still got to qualify for the SBA loans. I don't know if you can qualify, so you got to look at it individually. So just because one company does it doesn't mean it's something that's right for you. It's something that's really important. The other part of that big $600 check is, and again, we're still looking for some nuances to be filled out here, but essentially those who normally wouldn't get unemployment, those who are maybe independent contractors, people who are self-employed, people that otherwise just can't get unemployment, if the states themselves agree, they may be able to now not only get the $600 a week, they could also potentially get whatever they otherwise would have been qualified for if they are qualified for unemployment on top of that too. So you could look at people who are in this big pool of other employed individuals getting it, but we have to come up with the dynamics of how we do that. And as you might have heard, we have such an influx of unemployment now in the state of Michigan. They're asking people to apply on certain days depending on what letter their last name starts with. So you can tell this is going to be kind of a big issue of how we do it. And I'm sure the people down on unemployment are going to be able to get that done. But there are several layers that we have to look at. Number one is, are you an employer that has to pay the leave? What type of leave do you have to give and what circumstances? And I think that we talked about the Department of Labor has given us pretty good guidance on that. I think that's a really good place to start. You can look at what's a joint employer. A lot of people are saying, well, I have two different operations. Do they add up together? Hey, it's addressed right there. You use the new 4-prong test from the FMLA. I think they really did a good job of helping you out. The second component is going to be, okay, let's say I am or I'm not into the extended FMLA, or that am I the type of person who can actually have people come to work? And then individually as a business decision, should I lay off? Should I have people work from home? How to handle it? And then the third component is, what's in the best interest of my company? Should I get this loan? Am I going to qualify for this small business loan? And I think at the end of the day, that's a decision you have to make individually, and you have to look at it from a business and financial standpoint. I think a lot of people are crunching numbers right now. And then the final thing is, what are you going to do with your actual employees? Do you want to keep and retain them when this is done? We don't know when it's going to be done, but ultimately we're going to come back to work, right? We hope sooner rather than later. Whatever you do is going to be a component of a lot of different things. How did you treat your employees? How did you communicate with them? Did you run around with your hair on fire, or did you put your head in the sand? Is that going to have an effect if things start opening up? So can you give people benefits while they're on a layoff or a leave of absence? A lot of times it's going to depend on your healthcare provider. If I decide that I'm too small and I can't afford to give you the paid leaves, is that going to have an impact when this is over and people are going to leave? Those are the real world considerations on top of what I think is a fairly simple, once you step back, read the regulations, kind of go through the questions. Once you find out who you got to pay, who you don't have to pay, and you know that it cuts off if you decide not to do it, once you find out how to treat your people and work with them, I think that's really what's going to be the real world effect here. What's going to happen next with employment situations. And that's something that's an HR professional and people who are business people probably have to determine better for your workforce than any legal aspect.
Cliff, that's a fantastic point to make. Obviously the financial component and getting through the crisis is critically important. But, when we come out of this and we emerge on the other side, we want to make sure that we have, strengthened our teams and, we're not trying to rebuild our businesses from the ground up with our staffs. And, Julie, if you want to add to that as well, I think that's a great point to make, Cliff.
Oh, sure. And on the unemployment, just a couple other factors on the unemployment. Yes, there's a $600 per week, but there's also the ability to get funding for that first week of unemployment. So people typically don't have the benefit available during that first week. And then the other thing is they're adding on 13 additional weeks on the backside. Now, as I say that, I will tell you, while we were on this webinar, I got an alert on my phone that the governor's live streaming now on unemployment benefits. So it could change. I'm not sure what is happening on the live stream. So I will put that asterisk on anything that we say relative to unemployment. But, I think to Cliff's point, you think about, the benefit that's available based upon that additional $600 when you think about if you have to have any of those thoughts relative to your business. In Michigan, I will tell you as well, for those of you, if you haven't heard the term, there's also a thing called work share in the unemployment arena. So there's an opportunity to reduce people's hours, take advantage of a work share benefit from an unemployment standpoint of view, and use that as a methodology to try to get your employees' income as close to whole as possible. So work share is a benefit that is available in Michigan. It's, an employer unemployment program, let's call it, but it supplements for somebody who's on a reduced hours program as opposed to, completely being furloughed and relying on unemployment completely. So keep those things in mind as you kind of factor forward on, how do you transition if you need to, how do you think about those things? But, there's many different ways to look at, kind of how you move forward with all of the different pieces. But the elements of the CARES Act is, very much important. I will say from a HR professional standpoint of view, and I just started looking into this weekend, but please, for those of you with 401k and retirement plans, there's also provisions within the CARES Act relative to distributions and loans. So, this has a lot of different components on a lot of different factors of HR, and we're all trying to learn as fast as we can from the fire hose, right? So just to know that there are things that you need to look at also from your 401k standpoint of view. If you have a TPA or somebody who's helping you from an administration standpoint of view, they should be on top of that for you. But keep in mind that there's some provisions under CARES for 401k. So all of that together, there's a lots of different, financial relief available in a lot of different pockets. And again, as the larger employer who doesn't technically have to pay that leave, how do we look at our benefit programs? How do we figure out how we how do we help people make good decisions? So, we don't want people to make decisions on whether or not they come to the workforce based on their balance in their PTO account or their personal time off or their vacation, whatever, acronym that you use. And so that's one of the things that, has been a big discussion point for us is how do we look at our programs that we have already in place because we are the larger employer, but how do we help people make good decisions and make the right decisions for their safety, for all of our employees' safety, and for our business, and not using, whether or not I have PTO or sick time available to make the right decision. So, that's something that as a larger employer, it's just not laid out, just not as easy to figure out. But, when you're looking at that, the PTO, how do you help them make right decisions? If you have to look at any form of staff right sizing, how do you understand the full unemployment benefit CARES Act? How do you understand the mechanisms of work share? And so, it's a lot of Excel, fun with Excel spreadsheets to try to help you figure out what those things are, and then as well, be sure that you're writing and modifying your policies so that you have everything in writing relative to any changes that you make during this time. So it's, and then the last component, I'll say it again, is then you got to communicate all of that out to your employees, because if you have you have all these things in place and you're not communicating those out, the employee just doesn't know what's going on, and to them it feels like, my employer's doing nothing, when I can guarantee that every single one of us on the call are doing a lot to try to navigate through these unprecedented times. So you want to be sure that everyone's aware that you are spending that time.
I think those are great points, because at the end of the day, everybody wants to ask, look, what should I do, right? Is there a one size fits all response? And the answer is no, there's just not. This is the problem with this law and these set and series of laws. They not only keep in their dynamic, and we can get our hands around them, but ultimately it is so individualized based. You have to make a decision based on all the information you have. And one of the things that makes this more difficult, it's not like whether we should or shouldn't, comply with the Americans with Disability Act. Well, the answer is yes, you have to. But then you get into, well, how do you do the individualized accommodation? That's really what we're looking at. We're looking more at, look, there are unemployment components to this. There are real world components to this. There are business loan opportunities, but then there's, are we going to be able to recover? Are we going to be able to keep enough of our workforce to get that actual small business loan, somehow forgiven? Or, you know what, I don't care if I forgive it. It's a pretty good rate. I'll take it anyway. Everybody has their own decision. You talk about unemployment, and obviously, there are opportunities. There's a work share program. It's been around forever. They've relaxed some of the obligations. That's really what they've done, is just said, hey, we don't really care if you've had really good. We want you to keep people working. Of course, that sounds good in a bubble, but if you're not working and your operations are done because none of your customers are running, how are you going to keep people working? What are you going to do? How does that work for you, as opposed to a place that says, look, everybody's working anyway. They're just working from home. But not 20% or 30% of the time. Maybe because you're inefficient, we're not going to need you. Or maybe you're more efficient at home. I don't care. Maybe it makes sense. You get yourself an agreement. We'll keep your benefits going and meet all the criteria. Or you might just say, I don't want to do a work share program. It's too much, too entailed. I'm just not going to pay you as much. I'm going to reduce your salaries. I'm going to go ahead and have a decision where I can do that. And that has nothing to do with these laws. That's a business decision. I could say, look, based on the fact that we're going to lose so much revenue, I'm going to take a person who's salaried and I'm going to reduce their income. I'm going to reduce their income. And I say, well, wait a minute, make sure just because we're in an emergency, you don't reduce it below the normal threshold that will allow you to keep them as a properly exempt employee. So you got to think about, oh, okay, I didn't think about that because I was rushing to try to save money. Can you convert them to hourly? Well, you don't want to be going back and forth every other week or you'll lose the exemption, right? So you got to be careful with that. Can I reduce somebody's hourly pay in general? Sure, go ahead, take them down. But you can't take them down if they got an employment contract. So you got to make sure, do I have an employment contract? When does it end? What discretion do I have under that? How does that affect their ability to continue to have wages? If I reduce your hours so much, will I fall below the threshold for health insurance? And how does that interact with some of the other benefits I have? There are a number of variables, but what I call them are normal business variables. All right. So you have ups and downs in your business no matter what. All you do is you take these facts that we have for this law and you fit them into your normal business variables. And I'll give you an example about this extension to the FMLA. If I have coronavirus, if I'm tested positive and I need to be out of work, whatever, I get paid, right? I get paid under the sick leave. I'm not going to get paid, however, under the FMLA extension. That's the weirdest thing about this law, right? I basically get up to 12 weeks of extended FMLA for the ability to care for my child, my son or daughter, which is defined as, basically the same as it is under the FMLA. With most of it's under 18, unless you have an incapacitated a person who's over 18 with disability, same as you would under normal FMLA. But I'm not going to be covered by paid FMLA for that absence if I'm in the hospital on a respirator. That's not going to apply to me. What's going to apply is the first 80 hours. Then after that, what happens is I go into normal FMLA. It still has to interact with each other. And this isn't a new 12 hours on the top of regular FMLA. What this is part of your 12 hours. So if you have Susie, and Susie's at work and she says, I have a fever and I'm going to the doctor to find out whether I have coronavirus and get tested, and you put her off of work. Well, she'll get her sick pay, she'll get her sick leave, right? But whether she's now going to have FMLA for herself, normal FMLA is going to be dictated by the fact of whether she has any time left. If she already had a pre-existing issue, maybe she had intermittent leave, or she already used it for 12 weeks for childbirth or whatever it was in the last 12 weeks out of the last 12 months, she may not have anything left for normal FMLA. The same thing goes for Susie. If she says, I need to work from home, I want 2/3 of my pay for 10 weeks, because after the first 2 weeks or 10 days, I'm eligible. Well, the problem's going to be if Susie has burned through her normal FMLA allotment, looking back at your policy, she doesn't get it. She won't get the pay component. This is just one other component of FMLA. So it's whether you have for this or any other reason. So there's a lot of different things. So when you look at the accommodation, whether a person can be worked with, if you look at the FMLA and the paperwork that you're going to need for any type of illness, it's going to be because of hospitalization or something that interferes with their ability to perform the work because of a health condition, the same certification process is going to go through. The same analysis is going to go through. So again, we've had sicknesses before, we've had illnesses. I'm sure if you have employees, you've had absences before. The biggest problem is for small employers who've never had to deal with FMLA, there's this very limited issue. You're not going to have to worry about whether they exhausted their FMLA, because the answer is going to be they haven't, because they never had it before, right? So for this one limited issue, that's where you're going to be trying to put your head around what everybody else who's above 50 employees has been dealing with for the last 20 years, because FMLA, quite frankly, is probably one of the biggest issues HR people have if you have over 50 employees. And now what I first thought, and what a lot of people thought, was like, oh no, you mean on top of that person who missed all this time, they're going to get another 12 weeks so they can sit at home with their 17-year-old? And I said, well, calm down. Don't be so cynical. It's probably to myself. And then secondly, you say, no, the way this statute was written, it just is another reason for FMLA. So once you see that, I think it calms down a little bit of the exasperation of whether we're going to have to pay 12 or 10 weeks, for this extended FMLA, and whether it's an additional amount. And the FMLA's, the DOL's rules really do clarify that with some hypotheticals as well. So I think that's what we have to look at. Look at your situation, look at your employees, look at how you want to make these decisions based on a business judgment, and within the confines of these rules, make the right one for you and for your employees.
And, I think that's kind of a nice way to kind of wrap this up. I mean, at the end of the day, we all want to keep our doors open. We want to keep our staffs. We want to keep this region, connecting, growing, and thriving. And, these two acts give you, I think, more tools and resources to try to address this issue and, still check all those boxes that we mentioned before. We have about 10 or 12 minutes left. I'd love to go through just some of the questions. Thank you to Kim for, monitoring the chat function and shooting these over here. We'll just kind of just go right down the list. Does the governor's executive order to shelter in place qualify as a reason to take paid sick leave, assuming the employee can do no work as a result?
Maybe. And here's the bottom line. If the shelter in order says that I have to stay at home, right? If I have to stay at home, and as a result of me staying home, I'm working, okay? So I'm working telecommuting. And as a result of me not being able to go to work and I'm telecommuting, and my child has their school closed, and I say, I can't work, no matter what, I can't work, then I will qualify. But very specifically, and this is what we looked at, I thought by looking at it, that an isolation order is exactly what this governor's order was. But if you look at the FAQs from the Department of Labor, what they've said is, if you shut your business down, you're not doing business because of this, then you are not qualified. If you are furloughed because of the shelter in place order and you're not working at all, you are not going to be qualified. So if you're not working at all, you're not being paid, you're not working, then the shelter in place order is not going to have an effect. It's not going to qualify you for any of the sick leave reasons, and it's not going to qualify you for the extended leave. It's only if the shelter in place order takes you home where you're working otherwise, and then as a result of being told to go there, you have a specific, because of your condition, your quarantine, an individual you're looking for is quarantined, you've got those symptoms, and you're going to a doctor, or your child is otherwise going to be, out of school because of it. Those are the only things that are going to do it. So there is a tangible connection to a certain extent, but that's all it is. It's just on the periphery. And I think that's a lot different than what I would have expected when this all came down. I would have expected that an isolation order is what we're talking about here, but you got to remember the federal government passed the paid sick leave and the extension of the FMLA. The state did this. And when they were thinking about the CARES Act, I think if you look at it, the reason why there's more of a dovetail now is they're saying, look, if you're working, great, give them leave. If not, here's this massive unemployment amount. So I think that's why you're not seeing the same, like, oh no, what do we do now? We put the person on leave. We put the person on a layoff. We put the person, because of this order on this, not going to affect them for that purpose.
Great. Julie, anything to add, or is that?
The only thing I would add is I think part of that is for, again, you got to keep in mind, because a lot of times when we answer things, we got to keep in mind what our employer size is, right? So, I'll keep stressing that, because, even our employees coming in, they hear about the extended sick leave, they hear about the family medical leave extensions, and that is for the employers that are 500 and under. So, just always keep that in mind when you're looking at, the answers, and then looking at your employer size.
Can owners lay themselves off to assist in saving cash to companies' bottom line, allowing them to capture the 362 plus the 600? Any implications long-term in taking that move?
Well, I mean, the long story short is I read the CARES Act, on Friday. It appears on first draft that actually something that might be available for small employers, right? Or for every employer, quite frankly. But it's something that we're going to have a little bit of clarification on how the implementation of the CARES Act, because it says you have two components. Regular people who get unemployment get this, and there's some quirky language in there. And then it says people who aren't otherwise qualified for unemployment. Well, that would be people who wouldn't otherwise qualify for unemployment might be able to benefit from this if the state sets up an opportunity for you to, if you can meet the eligibility criteria for, hours, and the credited service and all that for your regular bank, whatever you would ordinarily get. It does appear on first glance, but I will tell you, there's lots of laws that say X, and then when the regs come out, you go, what are you talking about? It's not what it says. But that I just have to clarify this by saying it appears so. And I know people say, yeah, but I want to do it now. I'm like, okay, I understand, but caveat emptor, right? If you rush to make a decision based on the very basic language that's in this bill that was shoved through at midnight by a bunch of people who hate each other, and may not have been perfect, you might have yourself in a position where you shut down your business, you're looking for that big payday, and you don't get it. I'm not saying you shouldn't get it based on the language, but there's lots of stuff in the Constitution that people say, well, it says this. And then the court says, yeah, I know, but come on. It really says that. And how many times have we had ADA and FMLA issues where it looks pretty clear, but there's some quirky language, even harassment cases, right? You're like, so-and-so did this to an employee and they're a manager, and you're like, well, technically it's just horseplay, So I will tell you that my basic reading of the text is, if you're not otherwise eligible, you should be able to get it, but the state still has to sign up. They still have to have an agreement with the federal government. We don't have that agreement yet. So what it says and what it doesn't say still has to be determined. Just like I would look at this this quarantine or isolation order from the state of Michigan, that should qualify you for leave, but it probably doesn't, unless there's some exigent circumstance.
Julie?
Yeah, I mean, the only thing I would add is that, again, I'll go back to the big and small employer. A lot of that depends upon if you're public, if you're private, if, you have to file an 8K. So if you're a bigger company, I mean, you're seeing it in the news quite a bit that, CEOs are choosing to not take pay to try to help in the financial stability and the financial health of the organization. So obviously it is an available step that you can take. But again, for a larger company, again, you'd have to first look at public-private, filing requirements, you know, those types of things. So if you're the bigger employer, there's just a little bit more to, as always, to think about.
And we got about 5 minutes here. So I'm going to talk here. Somebody had asked a question. We're looking at the qualifications for the newly announced federal program for forgivable loans and grants to keep the employees paid without putting them on furlough or layoff. What do we need to be considering? So as you look at all of these different loan options, you know, what should these companies be considering as they weigh these options?
Well, I don't think we have enough time, really. I mean, that's a full hour to look at, and you have to look at your
Sure.
specific, right? That's the number one thing. But let's just say big picture, right? Say you are a small employer and they waived some of the guidelines and you might be eligible for this. I don't know if you already have one or you don't have one, but let's just say, I mean, there's a couple programs in CARES, but let's just say the big one that we're all talking about is the opportunity to pay your employees, and you're eligible for a small business administration loan. Number one, you got to qualify. All right. So they may say, no, you're not qualified for whatever reason. You're just a bad business or you're a bad risk. They might not want to give it to you. So that's number one. Number two, you got to know whether or not you're going to be able to float some cash, maybe get this thing done, right? So you get this in order. Are you going to be able to keep your employees employed and use this to actually pay them or not? I don't know what your monthly pay was, what your payrolls were in the past. If you've ratcheted up your employees extremely high the last 6 months or something, it might have a different effect than somebody who's been pretty static for the last couple months. But again, it's a decision that you have to make based on your business circumstances. The credit at the end that you might be able to receive in order to get this forgiven is going to be a request. You're going to put a request in for this. And I would hope that the request will be given and taken and everybody's happy about it. And you have to be able to know whether you're going to keep everybody employed roughly and whether you're going to be able to keep their pay roughly the same. And if you do those things and you are qualified, it may be a great bet. Here's the caveat, though, I would tell you. The president came out yesterday, just a couple days ago. He said, hey, let's get this thing going by Easter, right? Let's get this economy rolling. Now, I can't see why we can't do two things at one time. And now he's saying, well, maybe not quite so quickly. I'm looking at things. Maybe we're not going to be going back. And I don't know what your business is like. If your customers are all down, if you've got no money going on, and at the end of 8 weeks, you don't know whether or not you're going to be able to keep your employees rolling or not, I don't know whether or not this is or isn't a good decision for you because it's a business decision that could have some other factors you got to look into. If your company's still doing good, I mean, look, if you were making surgical equipment and you're a small business guy and you're rolling this the best time of your life, this almost could just make even more profits for you, right? Because you're going to have everybody rolling. You're going to continue to do work. You're going to get this loan. You're going to pay all the people with that, and all the profits are back to you. Yeah, that sounds like a great idea. Sign us up. Maybe there's some other questions for you if you're not doing that. So I just think that it comes down to this. You got to talk to, your accountants, your financial advisors, and you got to take a look at it from a legal perspective. We're doing that here, and we're, doing some risk analysis with different people, but it is different. It is unique. Every employer.
Yeah, Julie, if there's anything, that you'd like to add here, we're kind of on our final 2 minutes. So, we'll kind of add our, Jerry Springer final thought kind of to the program here. And as I mentioned, I know we've referenced several really strong resources. We'll make sure to include links to all these different websites and things in our follow-up email as well. So Julie and Cliff, Julie, if you want to lead us with your kind of final thoughts and we'll wrap up.
Sure. I mean, I think if anybody's hearing anything, we all want clear guidance. We all want black and white, and we're living in a world of gray, and the gray continues to shift what shade it is depending upon the minute, the hour, and the day. So, seek for information. I can't say strong enough, communicate. At Neogen, we're managing this across 9 states and 14 countries. So, you can just imagine the complexity that, you get into when you're looking at all of those different things. And what's happening is that what I'm finding is that states are starting to make specific protocols. Counties are starting to make specific protocols. And so staying on top of, if you are a multi-state employer or if you're a multi-country employer, everything is changing within each of those arenas constantly, which just makes the issue a little bit more complex. So communicate, 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 read, stay connected to resources, and final closing words is, and most importantly, wash your hands.
Cliff, anything to add here briefly?
I think the number one thing that we need to keep on top of, I do think that we are getting unprecedented clarity in a short period of time from the federal and state government on these things. I've never seen people try as hard as they are. They really are trying to make it as easy as they can. And I think the lender is going to be doing that. I think everybody's trying as much as they can to make this accessible. So keep watching the state of Michigan's website, because they are updating with an FAQ on who is and is not an essential critical worker. There was just an update from the federal government on critical infrastructure workers. Be very careful though, because the executive order that was signed here in Michigan refers to that initial one, because there's actually a lot of good clarity in this new one, but it may not be assigned by the governor, because it does open up some places like gun shops as critical infrastructure workers, things like that. There may be some political issues, so be careful. Make sure you think before you act. Look at the DOL. They continue to do it, and more importantly, for the money and credits that you get for giving people leave, the IRS is going to be putting out a form that you're going to put out, and it's going to have guidelines on documentation you need to be able to get the credits. We don't have that quite yet. The FAQ that's from the Department of Labor was jointly, in a way, put out with the IRS on this. Ultimately, you may need something that's simple for the expanded FMLA, is something from the website, from the school district of the child who is out of school, right, to prove that's what it is. But there may be more for the credits that you have. And again, you can get healthcare expenses that are related to it, but what they're going to want eventually when you put that in is going to be it's very, very important that you keep on with the IRS's website, which is there, and they're doing a good job of putting a lot of information that's usable for you. And then, obviously work with your counsel to make sure you're doing it the right way. But I will tell you, the most important thing is if you want to get reimbursed, you got to follow the procedures, and they are relaxing it. Look, the DOL just came out and said, look, for the first 30 days, we're just letting everybody kind of get their feet under them. We're not going to go out there and slap you with tic-tac, penalties, as long as you're trying to do the best situation. Understand they are working with us. They are trying to understand it. They put that guidance out. So keep on top of that. They're continuing to say things like that. For instance, if you take your payroll taxes, and generally speaking, take that money and put it in escrow, which you're supposed to do for the IRS. You can take, instead of waiting till the end of the quarter, you can just use that cash instead of putting it into escrow if you're eligible for this. So there is guidance out there from the IRS and Department of Labor on that point on their websites on how you can get that money now, how you can use it. So very important. Just keep on topic. Make sure you're continually keeping on top of all the changes, because they're going to change, right? We're going to have more and more responses as we go through.
But Cliff, again, that's another great point. As these documents and these clarifications continue to come out, that's a great opportunity to push out content to this group and make sure that you guys have the most up-to-date, current, and clear information that you guys need to do your business as well. So
hey, one more point though, I just want to make sure for those public employers that are here, unfortunately, while you are generally going to be covered, you're not going to get the tax breaks. So it's something to keep in mind. And it's unfortunate, because no matter how big you are as a public employer, you're generally going to be covered. But I guess they just figure, oh, well, you're a public agency and you don't get the same breaks as everybody else, unless they change it. Who knows, right? It could change, but it's important to keep that in mind as well.
Perfect. And I'm going to share, we didn't get to every question that we received in the chat function, but I will share that with both Cliff and Julie, and we'll go from there and work to try to get those questions answered as well. So with that being said, thank you guys for joining us for the first chamber hosted webinar with our friends over at Foster Swift. And I hope you guys all go out and, or stay in and make it a great day.
Okay.
Thanks, guys.